Honorable Muwanga Kivumbi Muhammad, Burhan,
Musa Mubiru
Joel Senyonyi Nagalet Bossa Eric, Great Council for the Accused Persons,
Assistant Superintendent of Business, Nicholas Abshai.
The application of Muwanga, who has been found upon medical examination to be a juvenile. My inclination is to take a judicial notice of the fact of the offense for which he is charged, having arisen out of political disputes. I am not sure if the tensions and the raised temperatures that came up in the result of those political disputes have been calmed down. So as such, I do not have the confidence enough that I chose the number 19, the juvenile in Muwanga would be out of the possibility of serious danger if he is released on bail. Accordingly, I decline his application for bail. It is ordered that he be remanded at Nagulu juvenile remand court, which, although it's situated outside the area of jurisdiction of this court, is within a reasonable distance of this court. That is it. I do appreciate the concerns raised by defense about the rather nebulous submission by prosecution concerning the progress of investigation, but I would rather trust that they are handling the matter in the best interests of justice. I am certain all of us are interested to see that there is a meeting of the end of justice in this matter. But however, this is not to detract from the duty on the part of prosecution to apply themselves as best they can, being mindful that their children's right to a speedy trial is at stake. So I am trying to adjourn the matter. You can agree on that.
Kyovudula n'obujulizi ne bw'oba wabbanga lyenkana ki tebajja kufuna bujulizi obugamba nti Honorable Muwanga Kivumbi n'abaana we bakwatira ewowe nti batujju abatujju abatya okwetaba mu kalulu kibubeera butujju oga nti kaakati ba agenti bange muleete DR form tuzikuŋŋaanye naki ewaka agende ku tali center obubeera butujju oluwawaabirwa nti kwabo abasibe kuliko abaana abato abataweza myaka 18 era nga tebalina kusibibwa n'abakulu. Era omulamuzi akkiriza kati abasindikiddwa Nagulu remand gye basibira abaana n'otandikiraawo okugoberera ensonga endala zonna kubanga mujjukira state yali ega nti bonna abantu bakulu ne statement n'ebirala kati ebeera wiini esookerwako then nga bwe tudda ku birala beiru n'ensonga endala nga bwe mulabye tujjukiza kooti kugamba state banguye okunoonyereza kwe bali mu kukola kubanga buli lutuula wa kooti seetega tukyanoonyereza munoonyereza biki nga tonnasiba muntu olina kusooka n'obanga obujulizi obulina kituze twogerako bw'oba tonnafuna bujulizi omuntu oba okwata waaki funa obujulizi bwe weetaaga then okwata omuntu ng'okakasa nti ono tumwinako obujulizi obuweerera ddala otandikiraawo naye ne batwetolooza naki tebannakomiitinga nga tulimu ebyo naye kirungi era kooti ekkiriziganyiza naffe ega nti kakati state bwe tunaakomawo wano mube nga muli ready okutandika okuwulira ensonga eno era ne gavumenti tugijjukiza bino byabufuzi bino si byamateeka kuba singa byamateeka abantu 7 battibwa mu maka ga Honorable Muwanga Kivumbi ne gavumenti nsirifu ku ebyo negamba nti ate mmwe abaafiirwa abantu bammwe yemmwe batujju baabalumba maka gammwe ne batta abantu bammwe kati yemmwe batujju naye gavumenti nsirifu ate nene ensonga tujja gidda kutugenda giremerako paka nsirifu ku bantu abattibwa abantu abo balina ab'eŋŋanda zaabwe bannayuganda era nga abantu bano nabo beetaaga obwenkanya ensonga eyo tujja giddira kubanga teyinza kusigalira awo anti abantu bano babatta ne biggwa ng'abalumbye mu maka gaabwe n'obattirayo si nti obasanze bali eyo mu bubbi bali mu kukola ki ensonga eyo gavumenti nga tujja kukkiriza egyebalame bwetyo
naye mujjukiro olwasembayo twababuulira nti bano abantu babayoola buyoozi okulonda tekunakutuuka kunaku lw'okulonda lwennyini ng'abamu baali ba agenti abamu baali bafumbi wa buugi baali ba ku kitundu babalonda nga tebabascreeninze kikulaga nti prosesi ya poliisi gyayitamu okuleeta abantu muno mu kooti nkyamu omuntu yenna ng'agenda kuleetebwa mu musango poliisi erina obuvunaanyizibwa obukebera emyaka gye kubano tekyakolebwa poliisi yabaleeta mu kooti ng'ebaleese ku musango ogwa malicious damage to property n'abamu ku incitement kati mu bbanga eryo byebaali mu kooti ate ne bateekako emisango gyebagambe egyannakongole gibaganya okuba nti no basobola okweyimirirwa wano tufunye omukisa nti okusaba kwaffe nti abaana abasibe abamu bato okunoonyereza kukiraze bulungi nnyo nga mulimu omu ku bo nga tannaweza myaka 18 emukkiriza kutula peers before court charged with an offence, the magistrate or person presiding over the court shall inquire into the case, and unless there is serious danger, the child release the child bail.
You said the child has a what?
Under Section 135 of the Children's Act, Cap 62. It's true the juvenile has a right to apply for bail. However, depending on the nature of the charges against him, it will be prudent, Your Worship, for the juvenile to avail sureties to stand for it.
Webakuta omulamuzi akubuuza webakuta n'ofuluma ebweru olowooza obulamu bwo tebubeere mu matigga bakusigaza alimanda obeera obulamu bwo bwaba tebuli mu matigga obeera ng'okyali munda.
Insists that our child is not yet 18 years. For us to prove that the child is not 18 years as reported. We seek your indulgence for this.
you have documents, any documents concerning his age?
She says, as she told me earlier, she was not prepared for this, but she can produce it.
You have the, what is this called? This one for immunization.
Immunization card. That's also a call.
On this report, or on the basis of the words of the mother to the accused person. If it's on the basis, Your Worship, of the words of the mother, Your Worship, those words are baseless. The mother hasn't brought any document to rebut the report. She knew that the issue of the age came into contention last time. Your Worship should have correct an immunization card or birth certificate for the said victim to prove her allegation. However, in absence of any document, I don't know what court will base on to direct for re-examination. Because per now there is no any document which has been provided to rebut the report.
It would be unfair if I did not. And we are saying it's the basis upon producing the. And this council knows that court is an expert of experts. We are seeking for just a second opinion on that basis, for which this mother said she's willing to pay. If it means to pay that price, it won't be too much to ask. And these are issues where we would concede. Why would you hide age? If the issue is about finding the real age, why would the state oppose? We reiterate, a young person cannot be kept in prison with adults on a report which is full of errors. It is an erroneous report. Council has no capacity even to point to what should have been the correct date brought. I will be here if the person who presented it or the examiner. On that ground,
Your Honor, we would like to appreciate that court has underscored the importance for a speedy trial, emphasizing the rights of the accused persons and really for court's time not to be wasted. At the last court appearance, court was very categorical that when we next appear, state should have a very well ascertained update, as opposed to the dilly-dallying of inquiries that are still ongoing, and yet we are hearing the same from the state. Our request, and we'd like to invite this court to be a lot more stern and a lot more categorical, so that at the next appearance, state is either ready or try to kick off, or we invite court, because, Your Honor, this court is clothed with a lot of authority, including dismissing a matter if state keeps dilly-dallying, as we are saying. But we would also like to invite the learned state attorney, perhaps even the office she works for. It's possible to issue a nolle prosecute and say you do not intend to prosecute because you do not have any evidence to adduce, so that we don't waste court's time, so that we safeguard the rights of the accused persons. We believe the state also has many other matters to deal with. So we invite court that it is a lot more stern, that if at the next court appearance, state is not ready with an ascertained update